So first, I would like to introduce Dr. Julie Lessard. She is from the University of Laval, and she will be speaking today on the influence, child characteristics, parental characteristics, and family history with child protection services on change from voluntary to court-ordered measures. Dr. Lessard, over to you.
Thank you. I will share my screen. Just a second here.
Perfect. And I welcome everyone to keep their cameras on if they would like. That is entirely up to you, but it's nice for the speaker. All right, looks great. Julie, go ahead, please.
Thank you. So good morning, everyone. You already said my name, Julie Lessard from Laval University, and I will address this topic of change from voluntary agreement to court-ordered measures. And this project, as you can see, was a collaboration. So I'd like to thank everyone who worked on this project with me. And let's start. So once the child safety and development is compromised, as you know, Child Protective Services will determine protective measures here in Quebec, Canada. There are two ways this can be achieved. It can be either through agreement on voluntary measures or through a court-ordered measures. And so this study focuses on families who agree to work with Child Protection Services through a voluntary agreement. So first I will address how the agreement on voluntary measures works here in the province of Quebec, and then I'll present the methodology and results of the study. So the agreement on voluntary measures is put in place when all members of a family agree to receive services from CPS. So this includes children 14 years and older as well. And it should be prioritized over court order measures when possible. So this allows to avoid the court process and reduce treatment delays, as it can be longer when you have to go to court, and be able to put measures in place quicker for children. So this agreement is a signed contract for up to 12 months, and it can only be renewed once for a maximum of 24 months, after the 24 months, court-ordered measures will be put in place. So what this agreement allows is for a more collaborative approach with families to increase involvement in order to resume the compromised situation. It allows more negotiation and communication with both parties and shared responsibilities. But for this to work, there are some necessary conditions. So the family must recognize that there is a problem. They must be able to actively participate and maintain participation over time. And the family has to be able to make an informed decision when choosing this agreement. In 2021, 54% of all measures put in place in the province of Quebec were agreements on voluntary measures. These numbers have been fairly consistent over the years, or the last few years anyway, and they do vary greatly from one area of the province to another. For example, in one area where they have the most agreements on voluntary measures, there's over 70% of those measures that are voluntary measures, while in other areas, there's over 60% of court-ordered measures. So it does vary between areas. So these measures have been put in place since 1979, but we still know very little about the families who benefited from them and how successful these measures were to terminate the situation without relying on court-ordered measures. So our study's objective is to examine the influence of child characteristics, parental characteristics, and family history with Child Protection Services on change from agreement on voluntary measures to court-ordered measures. It is an exploratory study. It's a very small sample, as you will see shortly. And so let's see. So the participants, we took all the families that entered an agreement on voluntary measures with CPS between September 1st, 2017 and August 31st, 2018, so pre-pandemic situation. in the Quebec City area. We took the information from Child Protection Services administrative data, and our sample consists of 312 children from approximately 195 families. So on average, family had between 1 and 8 children, but on average they had two children. So you find those different families in the sample. So children were about half and half female and male, between the age of 8 months to 17.5 years old, and the average is 8 years old. And we have mother's average age was 36, and father's average age was 39. So they're quite a bit, well, not quite a bit, but they're a little older than some than other families. Children, so what we did with data, the information we took was at the beginning of the agreement, and then we looked after 12 months. So we followed them. We took data for the first 12 months, the first agreement that they signed. And so at the end of the 12 months, what we saw, we had 92 families who had continued with voluntary measures. So they had a renewed contract after 12 months. We had 117 families who no longer needed child protection services. So the files were closed for a total of 209. And we had 86 children that were changed to court-ordered measures within or at the end of the 12-month period. So we included in the analyses variables that were associated with neglect and child maltreatment, and we did logistic regression models. So here's a list of the variables we looked at. We looked at age of the child, behavioral problems, externalized behaviors such as opposition, or internalized such as anxiety symptoms, for example, mental health problems, if there was a diagnosis in the file, the child's file, and then physical problems and school-related difficulties. For the parental characteristics, we looked at age, and we looked at a variety of individual risk factors, so such as ADHD, criminal activities, housing instability, placement as a child, inadequate environment, and we looked at the total number of risk factors present in families, and we had 22 in total. For family history with child protection services, we looked at previous reporting. Oops, just a second. I think you've lost my sharing.
Yeah, no worries. It happens when we have too many screens.
Okay, let's. Which one do you, oh, no.
I see.
Yes, just a second here.
Okay. Measures and analysis?
Yes, but do you see the comments and stuff?
No.
Or just?
No, just the slide. Looks
Okay.
good.
Okay, so family history with child protection services is previous reporting, previous measure, and a previous child placement. There you go. So basically we couldn't put all those variables at the same time in the models because there were too many for the sample size. So we did different subgroups. And so I will just show you the final model here. So the results show that child characteristics and family history with child protection services are not significant, but we do have some parental characteristics that are. So we have mothers who are 33 to 39 years old are less likely to go from voluntary agreement to court-ordered measures than parents that are 33, mothers that are 33 and younger. So the comparison group is the younger mothers in this case. Then we have fathers who are 40 years and older, also less likely to go to court-ordered measures than the younger fathers. Then we have the total risk, the ADHD for mothers. So mothers who had ADHD, who have ADHD were more likely to have court-ordered measures, and fathers with the total number of risk factors. So the higher the risk factors, the more likely they were to have a change to court-ordered measures. So in our sample, which is a small sample, we have child characteristics and family history with CPS that do not increase the likelihood of court-ordered measures. We do have some parental characteristics such as age, mother's ADHD, and father's risk factors that increase the likelihood. We do know that these factors are associated with chronic child maltreatment. At this moment, we don't have, or I don't have, a great explanation for this. It might be because these characteristics interfere with their ability to comply or to maintain active participation in the measures in place. If you think of ADHD, for example, that can bring issues with organization and planning, so that could maybe be a reason why, but it's really just an idea. The other things that could be, we might have to look at more into details is the interactions between certain characteristics rather than the cumulative, for example, number of risk factors. You might have to look at interactions to better understand this. And the other hypothesis or idea we will be looking into is the fact that it may not be the family characteristics at the beginning of the agreement, because we on a larger project for this, we do look at the characteristics of the families, and they're very similar from families who go to court, but rather what happens during the agreement. And so that might be more the reason why some families end up going to court. For example, when we were preparing for this presentation, we looked at by mistake, not because I was planning on that, but instead of looking at placement before, I looked at placement of the kids during the agreement. And what we saw was that the kids who had more than one placement during the agreement were 7 times more likely to end up with court-ordered measures. So it may be other things that need to be investigated. And we have some interesting data to do that. We have the number of practitioner or people involved in the files during the agreement. So we might need to look into those things a little more closely. So if you have any ideas or other possible explanations as to why we're not finding things like child characteristics or family history, which are also associated with chronic child maltreatment, then I would be happy to hear them, and you can write to me or address them at the end of the discussion. So we do have a fairly small sample, and from only one area in Quebec City. So this is a very interesting topic. It has not been studied much in Quebec City, in the province of Quebec, actually. And so a larger and more representative sample would be necessary or interesting, or a way to go anyway to explore this question. And the other thing that could be quite useful would be to have longitudinal data to answer this question, because since families can go for up to 2 years with the agreement on voluntary measures, and we only have 1 year, then we might be missing some of the families that do change to court order measures in that 2nd year. And so that would be really something to look into in the future. And so thank you for your time. And you see, you have my email there, but you also have it in on the website for the conference. Thank you.
Thank you so much, Julie. Really interesting. And thank you for those takeaways and where you're going next with your research. So as you have questions, please note those, and we will save those for Julie at the end of the session. Next, I'd like to invite Dr. Manuela Garcia Quiroga from Chile. I hope I said that correctly. And she is going to be presenting on challenges for child's participation in family courts. Over to you, Manuela.
Okay, thank you. Can you hear me?
I can hear you.
Okay, great.
And let me, I don't see your screen yet, but I can let you know.
I will share it now.
Okay, I see your slides.
Sorry for that. Okay.
Okay, excellent. Go ahead, please.
Yes, well, today I'm going to present the results of a part of the project. We have a big research project regarding children and adolescent participation in the decision making in alternative care system. So we have in that big project the children, professionals, lawyers, and judges, and I'm going to present today what do judges think regarding child participation in family courts. First of all, some ideas of previous research in the topic, international research, so no research in Chile yet. We know that there is greater likelihood of discomfort when in children when they are not consulted in the process than when they are consulted or included in the process. We also know that listening is not fully guaranteed or protocolized in many countries, so it depends. It's very variable, and it depends on the criteria, personal criteria of the professionals involved in the case. Although it's stated in the Children's Rights Convention, but it's not fully guaranteed in all countries. And there is a tendency to be to the children be interpreted by other adults involved. So adults speak for the children rather than listening to the children's voice directly. In the Chilean context, just to mention some important factors, we have a highly judicialized system, so we don't have administrative or non-court ways of solving protectional cases. So they all go in court and they all need a judge statement in order to go to alternative care or any other measure. We have a lack of training in especially in the judges. Judicial system is very, it has not included important training regarding working with children, talking to children, and several other important topics of working with families. We also have, for one case, several judges during the process, so it's difficult to make a follow-up, and it's difficult for the children and families to get to know the person that will make a decision in their case, because the judges change every time the family goes to the court in one process. And there also is a high case overload, so judges have very little time to talk to the families and go through all the information regarding the cases. Now to talk about our study, the methodology was an exploratory qualitative methodology, a very initial study, because there are no studies, previous studies here regarding this topic. So we just wanted to have an idea of what was going on to then maybe design a bigger study at the future. The objective, the main aim, was to understand the opinions of family judges in the participation, regarding the participation of children and adolescents in decision-making process in protection cases. We use semi-structured interviews based on a Bauman's model of meaningful participation. That's a model that specifically designed for protection, participation in protection, in child protection, that includes informing the children, listening to children, and involving children's views in decision making. So we explore these three dimensions in the interviews with judges. The participants, as I say, is a very little study, qualitative, in-depth study. We have 12 family judges with at least 10 years of experience and daily interaction with children and adolescents in the work. Now talking about the results, we have 4 main themes that were characteristic of the discourse of the judges. First, what we call the judges' criteria. I'm going to explain that later. Second, discretionary practices. The third, maturity issues. And 4, structural difficulties. So in the first of them, judges' criteria, what we found is that the judges say that the right of participation, they recognize it's important, the children's right to participate in the process, but they have very ambivalent views of it in practice. So theoretically, they say it may be important, but then when we go to the practice, it's very ambivalent, very different. They have a positive view in general of the child's report, so that child's report is useful for their decision, but they have negative notions about the presence of the children in courts, especially linked to possible risks for the children and fear of victimization or any negative consequence that they think they might have in children. They have concerns for the welfare of children and adolescents during this process. So then we have like a quote of one of the judges says, "It would be interesting to measure the impact that coming to court has on the children, or how they feel, or what their expectations are, or what they would like. That is what I would like to know. What is the impact on the children, and if they really feel harmed when they come to court, or maybe they feel considered. It could be that the children feel considered." So they don't really have a clear opinion about this. They think it may be important, but maybe it could be harmful, so they are not sure about it. Then the other theme was maturity issues. So there are a lot of quotes and references regarding that for smaller children, younger children, it's more complex. So it's more difficult to know what they think, what they feel. Judges don't have the tools for talking with the smaller children. They also have the idea that children can't understand what is happening, so it's not worth giving them information. And the inclusion, the listening of these children depends on the capacity they have of verbal expression. So the judges don't have any other tools for younger children, for children that are not very skilled in verbal expression. Judges need to listen a more adult discourse to take them into account. And for that same reason, there is a higher validation of the adolescents' views comparing with the children or young children views. We have a quote there: "It depends on his degree of maturity and development and the knowledge he has of his situation, because children who live with adults who are abusers, that is their life. They do not know that there is a life in which adults do not maltreat them." So we can see that they have this idea that children don't understand, don't know, can't express, that it depends greatly on the degree of maturity and verbal expression, the capacity to participate in the process. The third theme was discretionary practices. So the listening, the inclusion of the opinions of the children depends way of the judges' criteria, personal criteria. They are non-protocolized procedures, so some judges never talk to children, never give any information, never listen to them, while some other judges include them, even younger children. Other judges only include adolescents or older children, etc. So there's no standard procedures. They're based on judges' own experience, as personal experience and personal skills. And they have a lot of fear of the risk of re-victimization. We have a quote there. I would like us to have guidelines directly designed not to harm children in the interview, because we all use the skills we have, or maybe not the skills, because we may not have skills to talk with a child. But it would be good to have a universal tool, perhaps, or a way to do things. So you can see here that they lack tools, they lack training in how to talk to children. Just a second. Sorry for that. And the last theme was structural difficulties. So we see here lack of training, lack of time, and also some issues regarding the HESL rooms. They say they don't have tools, they don't have training on how to do this inclusion of children, these ways to habilitate child participation. They also don't have time because they are overloaded of work. And some HESL rooms were implemented in the courts, but they didn't include in the process, they didn't include judges' vision. So the rooms, these rooms with a mirror that can be used for interviewing children, were located in very, very far from the office that usually judges use to interview children. And because they are very overloaded with different cases, they don't have time to walk actually to that place and come back for each case. So they don't use these rooms that could be useful. We have here some quotes. We should all have like a uniform procedure, they say, or protocols of having for example, a playroom or pencils, or having a glass with water to make the children feel a little bit more comfortable and forget a little bit about the conflict. Another judge says, I think that in general, no government has been able to generate state policies around the children. So we have a very harmful procedure because we don't have people trained to take care of it. So we can see here that they need a lot of training or help in order to incorporate children's views in the process. Some final considerations. Improvements in the system must include judges and professionals' views. There is a need to protocolize mechanisms for child and youth participation. And it would be important to include several ways for participation according to age, gender, disability, ethnicity, etc. And this must be done together with the judges and including their views and offering them tools and different possibilities in order to access children's views, opinions, feelings, etc. So thank you very much, and there is my email address in case you want to contact me regarding more details of this research.
Thank you, Manuela. It's becoming increasingly clear how judges need the training to really be able to support children in court. Thank you so much. So again, if you have questions for Manuela, please note those and we will come to those at the end of the session. Next, I'd like to invite our last speaker for this session to come to the stage, Mr. Wajahat Ali from Pakistan, who is going to be presenting on the state of human rights of child offenders and child justice system in Pakistan. Welcome, Wajahat. And I do see now your shared screen.
Thank you.
Okay, please go ahead. But I don't see your presentation yet. So let me give you 1 second.
Can you
Perfect.
see now?
Yes, excellent. Thank you. Please go ahead.
Thank you, Pagati, for inviting me to present my talk. The work I'm going to present in today's ISPCAN's Quebec City Congress is entitled as the State of Human Rights of Child Offenders and Child Justice System in Pakistan. I will present in my talk about the situation of child justice system in Pakistan and up to what extent it protects the human rights of child offenders in Pakistan. This is an overview of my presentation. Presentation is divided into 5 sections. In the first part, I will talk about the human rights of child offenders in Pakistan laws, and thereafter I will discuss about the child justice system of the Pakistan. And after that, I will talk about how human rights of child offenders are violated in the child justice system of Pakistan, and then some suggestions for upheld of child justice system and human rights of child offenders in Pakistan. And at the end, I will conclude my presentation in the concluding section. The purpose of my presentation is to know about the state-of-the-art situation of child justice system of Pakistan and human rights of child offenders when they are involved in the child justice system. Some suggestions for the improvement of these issues will also be prescribed. So the first part of my presentation is human rights of child offenders in Pakistani laws. Human rights of child offenders in Pakistani laws are protected both in General Thematic Code as well as in exclusive acts. First, I will talk about the General Thematic Codes. The first General Thematic Code is Constitution of the Pakistan, which is the supreme law of the Pakistan, and it protects the human rights of child offenders. There are different articles in it. As you see on the screen, Article 9, it talks about the right to life of every person and guarantees every citizen the state shall protect the right to life, which is saved according to the law. And Article 10 provides safeguard as to arrest and detention. That any person who has been arrested or detained in the custody of state, he shall immediately be informed about the ground of such arrest. And the person who has been arrested, he has the right to consult and be defended by the legal practitioner of his choice. Next, Article 10 here talks about the right to fair trial of every citizen of Pakistan or every offender. And then Article 12 and 13, it provides protection against retrospective punishment, double punishment, and self-incrimination. Article 14 talks about the right to dignity of every person. State shall protect the right to dignity of every person, and no person shall be subjected to torture for the purpose of extracting evidence or confessional statements. Article 25.3, 26.2 provides that state shall make special legislation for the protection of women and children. And then Article 37b, the state shall provide inexpensive and expeditious justice to the citizen. Next General Thematic Code is Code of Criminal Procedure. There are different sections which protect the human rights of child offenders. Section 29b, it provides that when the cases of children appear in any particular area, then those cases will be decided by a special judge, which is appointed by the provincial government in any specific area. Those cases would be tried, adjudicated, and punishment would be accorded by a special juvenile judge, which shall be appointed by the provincial government in any specific area. Section 399, it says that in case of sentencing to the youthful offenders who are below the age of 15 years, instead of sending them in prison, they shall be sent to the reformatories for their rehabilitation. And next section is 497. It says that in case of child offenders, they shall be given special treatment, and they shall be awarded granted bail even in cases of non-bailable offences. If the age of child is below 16 years of the age, he is eligible for the grant of bail even in non-bailable offence. Next general thematic code is Pakistan Penal Code, which provides different punishment for different offences which are committed in Pakistan. There are some sections which are specifically apply for the children and give them special relief in cases of punishment. Like section 82, it talks about the criminal responsibility of any child. It says that nothing is an offense which is done by a child who is below the age of 10 years. So criminal responsibility starts from the age of 10 years in Pakistan. And the relaxation in the age of criminal responsibility has been extended up to the age of 14 years if the child has not attained sufficient maturity of understanding to judge the nature and consequences of his conduct at the time of commission of his offense. Then the relaxation has been extended up to the age of 14 years. And that's section 29AA, A and E and I. It provides the definition of adult and minor. Adult means the person who has attained the age of 18 years, and minor who is below the age of 18 years. Section 306A, 3081, it provides punishment of murder not liable to death sentence. So if a child commits a murder, he will not be awarded the death sentence. Section 337M, hurt not liable to punishment of hurt. So if a child commits the offense of hurt, he will not be awarded the same punishment. Next general thematic code is Qanun-e-Shahadat Order 1984, or Law of Evidence. It provides about the testimony of the child is admissible in the court. The only condition it stipulates that it is up to the satisfaction of the court. That if the court is satisfied that the child is able to understand the questions and give rational answers to those questions, then he is a competent witness, and his evidence would be equally admissible as the evidence of an adult person and could be relied upon to decide the cases. Police Order 2002, it describes the attitude and responsibilities of police towards the general public and the children. Rules and orders of the Lahore High Court, Lahore. It provides instructions to the criminal court how to try the cases of youthful offender and what special treatment should be given to youthful offenders in the cases. Some law reform reports of Law and Justice Commission of Pakistan. It provides recommendation for reforming the juvenile justice system and amendment in the Juvenile Justice System Ordinance 2000, which is the law which has been repealed now. And then there is an exclusive act which regulates the child justice system of Pakistan. That is Juvenile Justice System Act 2018. Basically, this law provides a special procedure for arrest, investigation, bail, trial, detention, sentencing, and rehabilitation of the child offenders. I will discuss this law in the next part when I will talk about the child justice system of the Pakistan. So second part of my presentation is child justice system of Pakistan. As I said before, that the law which regulates the child justice system of Pakistan, it is Juvenile Justice System Act 2018. It has been enacted in 2018, and it introduced several new features in the child justice system of the Pakistan, which are very important and helpful for the protection of the rights of the child offenders. Some features you can see on the screen. It classifies the criminal offenses into three categories: minor, major, and heinous. Minor offense means then where the punishment is up to 3 year imprisonment with or without fine. Major offense means where the punishment is more than 3 years and up to 7 year imprisonment. And heinous offense means where the punishment is death sentence or life imprisonment or punishment of more than 7 years imprisonment. All minor and major offenses are available for child offenders. And this law says that state shall establish exclusive child courts throughout the country, as well as establish observation homes, child rehabilitation centers. Observation homes is a place where child shall be kept temporarily after being apprehended by the police or after taking remand from the child court or otherwise for conducting inquiry or investigation. And observation shall be made somewhere outside the police station area. Child rehabilitation center are the special kind of prisons where the children will be kept and given given vocational, technical, educational training for their moral, mental, psychological development, for their rehabilitation. And this provide that determination mechanism. Whenever the child will be arrested, it is compulsory upon the investigation officer to determine his age. Or if a person physically appears to be a child or claims himself to a child, then it is compulsory that an investigation officer determine his age. And age can be determined by seeing his educational document, his birth certificates, or other document. In case of absence of these documents, the age will be determined by using medical evidence. Diversion is an alternative way of determining the responsibility and treatment of the child offender without resorting the formal judicial proceedings. So all the minor and major offenses would be compoundable for the purpose of diversion, and diversion shall be exercised through juvenile justice committees. And juvenile justice committees shall exercise the diversion through different modes. For example, restitution of movable property which the child has stolen. He will return that property. The committee can pass this order, or reparation of the damage caused, or awarding him written or oral reprimand, written or oral apology that will be given by the child offender, or placement of child offender in the community service, or placement of child offender in the child rehabilitation centers, or awarding him fine or to pay the cost of the proceeding. That punishment can also be awarded to the child offender. Moreover, this law says that no corporal punishment would be awarded to the child offender. He will not be handcuffed, put in fetters. Special provisions for a female child offender. Female child offender will not be apprehended and investigated by the male police officer, and she will be kept in the child rehabilitation center, which were made exclusively for female child offender. Protection of the identity of the child shall not be revealed, nor it should be published in any newspaper, journal, or magazine without the permission of the court or investigation officer, or the permission of the juvenile or his guardian. Next feature is dispensation of physical appearance of child before court. Court can exempt the physical appearance of the child in the court and can record his statement through audiovisual technology, and he can join the court proceedings through online link. Role of probation officer has been strengthened, and there are special provisions provided in this law that child can be granted bail under the supervision of probation officer in case of sentencing. Instead of sending him in the prison, he will be released on probation under the supervision of probation officer. No death sentence or rigorous imprisonment would be awarded to the child. Removal of disqualification attached with the conviction. If a child has been convicted, he will not be disqualified for any offense. Any disqualification which is attached with any offense, he will not be eligible for that disqualification. And next is bar on preventive detention. No child offender would be arrested for the purpose of preventive detention. These are some features which I explained to you. Now, the next part of my presentation is how human rights of child offenders are violated in the child justice system of the Pakistan. First violation of human rights of child offenders is execution of child offenders. Pakistan has lifted the de facto moratorium on death penalty in 2014 after the terrorist attack at Army Public School, Peshawar. And since then, Pakistan has executed more than 500 condemned prisoners, which makes Pakistan third more prolific executioner in the world. And among those 500 condemned prisoners who have been executed, 6 child offenders have been executed. These are the names of those child offenders who have been executed. And their ages were 17 years, 15 years at the time of commission of offenses. And their executions were conducted in 2015 and 2016. This is because they were tried as an adult offender. That's why they were awarded the death sentence. Although Pakistan put ban on awarding of death sentence to the child offender under juvenile justice system Act 2018. So next violation is police brutality, torture, custodial death, and rape. Police brutality, torture, custodial death, and rape are common feature of policing in Pakistan. Anyone can be victim of police brutality, torture, custodial death, and rape. But children are more vulnerable because they are not aware of their rights. Justice Project Pakistan is an NGO which released a report about abuse of juvenile by Faisalabad police from 2006 to 2012. In that report, Justice Project Pakistan discovered that Faisalabad police have arrested some adults as well as child victims on basis of false allegations against him and relied on torture and abuse as a principal means of interrogation.
One minute, Wajahat, okay? Thank you.
1 minute left.
Yes.
Oh, I have to then move quickly.
Okay, thank you.
Because there are a few slides left in presentation. So Faisalabad police applied different methods of abuse and torture to the child offender, like severe beating, suspension, stretching, witnessing other people torture, sleep deprivation, solitary confinement, light deprivation, confinement to small spaces or exposure to extreme temperature, cultural humiliation, sexual violence amounting to penetration, sexual violence not amounting to penetration. As you can see, in the cases of sexual violence amounting to penetration, sexual violence not amounting to penetration, cases of child offenders, child victims are double in number as compared to the adult victim. Next violation is imprisonment of children in adult prison. There are lack of rehabilitation center and child prisons in Pakistan. A total 112 prisons in Pakistan. Out of 112 prisons, 7 are made for child inmates in Pakistan. There is no child prison in KP, Balochistan, GB, AJK. So next violation, human rights violation of child offenders is pre-conviction detention for child under trial prisoners. Under trial prisoners are those whose trials are in progress and they have not been convicted by any court of law. And a report was released by National Counter-Terrorism Authority Code and ICRC in May 2018, and it revealed that there were 1,343 child prisoners in 112 prisons of Pakistan, and out of these 1,209 or 90% child prisoners were under trial prisons. You can see in the graph that in Sindh province, there were highest number of child under trial prisoners, 93%, and then Punjab, 91%, KP, 88%, Balochistan, 87%, and GB, 83%. Some other human rights violation of child offenders, prescribed time limit for pre-conviction detention is not respected. Law said that the trial should be completed in 6 months. It is not respected. Non-exercising of age determination protocol in child offender cases. Low birth registration rate of children in Pakistan. So when a child commits an offense, he has no proof to prove his juvenility. That's why they were tried. They are tried as an adult offender. Their trial is conducted under anti-terrorism code because this law has granted overriding effect over all other laws. And low minimum age of criminal responsibility, which is 10 years, which is against the UNCRC General Command number 24, which says that age of criminal responsibility should be 14 to 16 years. So this is the violation of human rights. Inadequate legal representation in child cases, and children are granted life imprisonment in their cases. No exclusive child court to adjudicate on child offender cases, and incapacity of judges about child protection laws. And some suggestion, this is the last part of my presentation. Some suggestions for upheld of human rights of child offender and child justice system in Pakistan. Pakistan should reinstate the moratorium on death penalty because 10% of current death row populations in the jails of Pakistan consist of those prisoners who were children at the time of commission of offense, and they have been awarded the death penalty can be executed one day in future. The person should increase the minimum age of criminal responsibility, that it should stay 16 years onward according to UNCRC Committee General Command number 24. Pakistan should enact exclusive legislation to criminalize torture because Pakistan has ratified Convention Against Torture in 2010. Full implementation of age determination protocols. Under trial child prisoners should be released on bail. Rehabilitation and provision of psychosocial support to child offenders who are imprisoned in the jails of Pakistan. And establishment of child rehabilitation centers, observation homes, and exclusive child courts. Capacity building training for police, judiciary, and probation officers so that they are well aware of the child protection laws and give relief to the child offenders when they are involved in the criminal justice system of Pakistan. and allocation of sufficient budget. Government should allocate sufficient budget for and resources for upheld of child justice system of the Pakistan. Conclusion of my presentation is human rights of child offenders and child justice system in Pakistan can only be upheld by fully implementing the Juvenile Justice System Act 2018. There are some references which are related to today's talk. All are my publications, which are published in international journals, national journals, international magazines, and newspapers. So all their online links are present here. You can access those. And thank you very much. Thank you for listening to me. Any questions, please?
Thank you. Thank you, Wajahat, and I appreciate you ending
I
there.
quickly bind it up.
I know the time goes very quickly, but I do want to save some time for questions and allow everyone a chance to make some comments. That's really 3 excellent presentations and very different points of view around the system of legal criminal prosecution and policy. So thank you to all 3 of you. So if you have questions, please go ahead and use the raise hand icon now. And I can call on you to make any comments or ask any questions. So as people are thinking about their comments and questions, I have a couple that I would like to maybe start with. So Julie, if you could please speak to this. A lot of your research has really analyzed what are those child and parental characteristics that, you know, in the family history that really influence whether children have voluntary or court-ordered measures. So I was wondering if you could comment on, based on what you've learned, what recommendations would you have for prevention or potential policies that you think would really, you know, help children in these cases?
Well, thank you for your question. Let me see. It's a very small sample, so I don't know if we're at the point of doing recommendations for practice or prevention here. We really need more data on this. But the fact that only the parental characteristics are coming out as bringing a change from voluntary to court-ordered measures, they are the proximal variables. So I mean, it is their decision to do a voluntary agreement, and why it ends up being a court-ordered measure over voluntary, I'm not sure, but maybe, you know, like those characteristics that are prevalent and strong and been there for a long time may be difficult to change. And so I don't know if there's a way to prevent the change to court order measure once we know that these characteristics can have an impact, because they're not so changeable, unfortunately. But
thank you. And I know it's a bit of a leap, and it's probably the next question that people who utilize your research will be asking themselves, but thank you for all the interesting data and information that you've gathered.
Yeah, and we hope that by better understanding what makes it that they change, whether it be the number of placement during the child goes through during the agreement, or the interaction between certain variables, or the practitioners they work with, the relationship that they build, whatever it is, I hope that we can kind of pinpoint it so that we can actually go and talk to practitioners and say, look, when you have this situation, it might be a little more difficult to keep them in those voluntary measures.
Right. Yeah, a lot of great information that your study has raised. So Manuela, you know, you spoke a lot about how to involve children effectively in child proceedings in court. I'm wondering what you feel might be, you know, whose role is it, at least in your country, to train judges? And how would you institute or bring about change so that judges are more informed about how they interact or engage with children in court?
Yes, thank you for your question. In Chile, I think the person in charge will be the Minister of Justice, because all family courts depend on the global judicial system. So it would be, I mean, a political negotiation maybe regarding that this topic is important and showing evidence, and because it has to be a decision taken by the authority.
Sure.
But I think that judges are quite interested in that. So they feel they don't have the tools they need to have.
Right.
And I think that's a good point to start, because they feel they need this training.
Right.
So I think we could do some improvements there, and that will help them in their work, and obviously help children and families. That's the main thing.
To be more effective. And these are the things I hope spark the ideas also for people as we go forward and, you know, trying to bring about improvement or change to the systems. It's been a really interesting presentation that you made.
I have a question for Julie. I don't know if I have time for that.
Yeah, please.
Okay.
And anyone else who has a question, please just use the raise hand icon and we can pose those.
It was a very interesting to listen to your research, Julie. And I was wondering if maybe a factor that could be explored, I don't know what you think about that, is that maybe the ideas or the attitudes of professionals toward these young parents, because one factor was the age of the parents. I think the younger parents were more likely to go to a court procedure. So I think maybe it